Welcome to Frank Bruno Law. Today I received a call. A person said that they've been physically separated. Her husband alleged that he had gotten divorced in another country and that they were divorced, and that's it. Now, the person that called me had no knowledge of being divorced. They were physically separate, and so she knew that they were not together. But it was a shock to her that she had been divorced, and he said that they had been divorced a number of years ago. So the question that was posed to me, and we had a conversation about how do you find out if you were divorced and all issues related to that, and can you register a foreign divorce, and a lot of questions. If you have questions about that, contact my office. We do handle divorce. My associate can field that question. I can also field the question. But today's topic is that question and the follow-up question. She asked if her children, the two children of the marriage, were still entitled to inherit from the father. And the answer is yes. So when a couple divorces, they divorce each other, but you don't divorce the children. So if there's at least three scenarios. If the husband or ex-husband that it may be, if the ex-husband had no will and never remarries, and his children would inherit by the rules of intestacy. If you die intestate, there's a plan in place, and the children would inherit with certain percentage issues, and I'll set that aside for now, but the children would inherit. If that person, the husband, remarried and he had a will, I'll go with the no will. If he had no will, his children would inherit along with his wife. There'd be a split under the rules of intestacy. Now, if the gentleman had a will, if he provided for his children, yes, they would certainly inherit. If he specifically disinherited the children, he said, I have two children from prior marriage, A and B. I make no intention, I make no specific bequest for these children. Then the children do not inherit. So it's still governed by what that gentleman would do. Is he going to specifically provide for the children through a will, specifically disinherit the children through a will, or not have a will and have the children inherit by intestacy? Is inheritance divisible in divorce? Right? So in divorce law, there's the general rule of equitable distribution. Equitable implying fair. That means anything that we have should be divided equitably. And most courts very broadly define that as 50-50, right? It seems to be fair that we divide things in half. Now, equitable does not require it to be 50-50, so each side may in fact argue against 50-50 distribution. Now, inheritance is not marital property unless you do something to change it to marital property. That's a commingling the inherited property, or transferring it in some way. And sometimes we can best describe these things by examples, right? Because we have the interplay of divorce law and equitable distribution compared to the laws of inheritance. So, if a person inherited $1 million and they inherited it today and put it into a joint account, but removed it tomorrow, well, it was probably an issue of convenience. It was probably stress or de-stress, right? Because they inherited this money. And at least in my example, to inherit $1 million, that person was probably, besides wealthy, they must have really loved you. So that's a momentary, or at least day thing, right? So $1 million went in. Now, if the $1 million was inherited today, deposited today into a joint account, and was not removed for a year, I don't know. That's a fact-specific question. Let me go to the opposite end. $1 million was put in the account today. 20 years from now, the couple gets divorced. Yeah, I think that's clear that ceased to be inheritance, and it became a marital asset because it was in the joint account for 20 years. So one day, probably not, or definitely not. I'll go on a limb and say that. This is not legal advice, right? This is a video. I play a lawyer in real life, but on the internet, it's just informational purposes only. So put the money in today, take it out tomorrow, fine. Put it in today, take it out 20 years from now, no. I give an arbitrary time frame of 10 years, no. Definitely marital property, right? It's my opinion. 9 years, yes. 8, 7, 6. We get all the way down. How about a year? I don't know. Again, why was the money left in there for a year? Now, I just used a sum of money, and that could have been cash or brokerage accounts. The thought process and the considerations would be the same if it was property. But in the next example, would it be an investment property? Would it be a marital residence? Could it be that you inherited a home and then the husband and wife moved into that home? Well, at what point does the inheritance stop being inheritance and change into a marital asset? Well, we have to take a look at that. If a person did inherit into a trust and then moved into that property, if it was in the trust for the duration of the marriage, it would never become marital property. Right? It's like living in your friend's house. Doesn't matter if you're there for 30 years. It never becomes yours. Right? So there you have it. If you have a situation that you would like to speak to me about, I like these different questions because they're novel and, it's mentally challenging. So give me a call or reach out to me through my website, frankbrunolaw.com.